Hello people, hello Ugandans. I'm by name Obirinjo Emmanuel Norudia Siata, a law student at Victoria University. Well, I want to appreciate those that subscribe to my YouTube channel, those people that follow me on my YouTube channel and other social media platforms, those who comment, like, and also share my YouTube videos. So those who have not yet started, who have not yet subscribed, I want you people to subscribe so that you can follow my beautiful videos, my beautiful teachings, my beautiful law lectures. So all of you Ugandans, I urge you to follow me, to subscribe my YouTube channel and also other social media platforms. Today, I want to talk about bail. I want to teach you about bail because bail is the constitutional right. It's a constitutional right provided under Article 23, Clause 6, Paragraph of the Constitution of the Republic of Uganda. And this is a right that's not automatic. There should be reasonable grounds that court deem fits to give you bail. So you will be asking yourself, what is this bail? From the textbook of A Guide to Criminal Procedure in Uganda by Justice Benjamin Odoch, it defines bail as an agreement between an accused person with his or her sureties, if he has any surety, and the court, that this accused person will pay a certain amount of money if he or she fails to appear for trial on a specific date. So, you should be also asking yourself, who is a surety? A surety is another person who guarantees that he or she will pay this sum of money if the accused person does not show up in court for trial on a specific date. The amount of money that you pay is decided by the court. And this amount of money you pay is what we call security. So, Ugandans, you should know that bail is a constitutional right. It's a right provided for by the Constitution of the Republic of Uganda 1995 as amended. And it's under Article 23, Clause 6, Paragraph A. Furthermore, you might ask yourself, now I've known what bail is all about, what bail means, and what actually a surety means, and what the money I give stands for what. It's a security. Now, who is responsible to give me the bail? Who can give me bail? Who can grant me bail? The courts of laws have power to grant bail. And the High Court has power to grant bail in any case because the High Court has unlimited jurisdiction. Now, for the fact that High Court has unlimited jurisdiction, so it has power to grant bail in any case, and normally deals with applications punishable with a sentence or a punishment of death. You will see Section 14 of the Trial on Indictment Act. Number 2, the magistrate court have power to grant bail in any case except in the following circumstances, or except in the following scenarios, or except in the following instances. The first instance is that the High Court cannot grant bail in a case triable by only the High Court. You should know, or you should put it at the back of your medulla oblongata, hippocampus, and hypothalamus, that the magistrate courts have limited criminal and civil jurisdiction, but the High Court does not have limited criminal and civil jurisdiction. For them, the High Court has unlimited jurisdiction. So, for the fact that the magistrate courts have limited jurisdiction, they cannot give bail or grant bail in a case which is triable by only the High Court. Another scenario where the magistrate court cannot grant bail, a case relating to an offense of cattle rustling, the magistrate court cannot grant bail. 3. Another scenario where the magistrate court cannot grant bail. A case relating to acts of terrorism, the magistrate courts cannot grant bail. Because here we are talking about heavy offenses with heavy gravity. The magistrate court cannot grant bail. An offense under the Firearms Act that is punishable with imprisonment not less than 10 years, the magistrate court have no power to grant bail. The 4th scenario is an offense relating to embezzlement. The magistrate courts have no power to grant bail. Another scenario, the magistrate court have no power to grant bail in an offense causing financial loss. The magistrate courts have no power to grant bail. Another scenario where the magistrate courts have no power to grant bail is an offense relating to rape, to acts of rape, contrary to section 123 of the Penal Code Act. Acts relating to all actions or an offense of defilement contrary to section 129 of the Penal Code Act and also 130 of the Penal Code Act. Now, section 100, defilement, according to section 129, is defilement of a girl under the age of 18 years. Then section 130 is defilement of an imbeciles and idiots. So, because these people, how much this person, an imbecile, can be above the age of 18, but these people are taken to be as minor people. So, if you happen to have sexual intercourse with this minor person, it will be taken as a defilement. So, the magistrate courts have no power to grant bail in such a case of defilement, because this one is a heavy offense which is not triable by the magistrate courts. Another instance where the magistrate court have no power to grant bail is in an offense where the magistrate courts have no jurisdiction. If a magistrate court does not have jurisdiction to try an offense, it cannot grant bail in such an offense. But the court with jurisdiction can grant bail. For example, the High Court can grant bail. So, except those circumstances above, those scenarios, those instances where the magistrate court cannot grant bail, the rest the magistrate court can grant bail. Another authority that can grant bail is the police. And here we term it has to be a police bond. So, a police officer in charge of a police station can grant you a police bond. Upon your arrest, if it is not demandable, if it's not desirable for you to be taken to court within 48 hours, because the law provides that you should be taken to court upon your arrest within 48 hours. So if it's not demandable for you to be taken to a court of law within 48 hours, the police officer in charge of police station can grant you bail. And then after granting you bail, a notice of such a police bond should be given as a requirement. And that is section 38 of the Police Act. That notice that law provides for that if a bail is granted, if a police bond is granted, there should be a notice of such a police bond. Another authority that can grant you bail is the justice of peace. So the justice of peace have the same powers as the magistrate courts. So that means the same areas or the same offenses where the magistrate courts don't have jurisdiction to grant bail or don't have power to grant bail, the same applies to the justice of peace. If you are to see the Justice of Peace Act, that where the magistrate court does not have power to grant bail, the Justice of Peace has no power to grant bail. Where the magistrate court can grant bail, the Justice of Peace also have power to grant bail under the Justice of Peace Act, if you to see Section 3 of the Justice of Peace Act. So dear Ugandans, I've come to my conclusion about bail, the first introduction about bail. And I would like to educate Ugandans that bail is not an automatic right, but it's a constitutional right. The court can grant you bail upon application for bail, but after reasonable grounds have been considered. Subscribe to my YouTube channel for more videos about bail, because we have just started a journey of educating about bail, and I'm going to be educating you more about bail until we shall finish bail. I wish you well, Ugandans. Subscribe to my YouTube channel and follow other social media platforms. I remain Birinjo Emmanuel Norodia Siata, a law student at Victoria University. I wish you well. I wish you good luck. Let's meet up next time.